Ladies and gentlemen, welcome back for our first session, Challenges and Opportunity in Building a Sustainable Global IPR Ecosystem for Promotion of Innovation in ICTE Sector. I would like to request Dr. Debasis Datta, Group Coordinator, R&D in Electronics and IT Group DIT, on stage to kindly moderate the session, Challenges and Opportunity in Building a Sustainable Global IPR Ecosystem for Promotion of Innovation in ICTE Sector. Before that, I would like to tell about few things about his profile. Dr. Debasis Datta, who would be moderating the session, is Group Coordinator for R&D in Electronics and R&D in Information Technology Group, DIT. Dr. Debasis Datta is currently the Group Coordinator for R&D in Electronics and R&D Information Technology Group of Department of Electronics and Information Technology, Government of India. Dr. Datta is also the Program Director for Special Manpower Development Program in VLSI Design and Related Software, SMDP. Some of Dr. Datta's special research areas include low power analog circuit design, biomedical electronics, and neural networks. Welcome, sir. A huge round of applause, ladies and gentlemen. Thank you. Now, allow me to welcome on stage the eminent panelist for this session, Mr. Raymond Lutz, Vice President, European Patent Office. Welcome, sir. Dr. A.K. Garg, Officer in Charge, ICD and Director, Innovation and IPR Division, DIT. Welcome, sir. Dr. K.S. Kardam, Joint Controller of Patents and Design, Indian Patent Office. Welcome, sir. Dr. Santosh, Vice President, Tata Consultancy Service Limited. Ms. Gabrieli, Vice President, IPR, Ericsson. Welcome, ma'am. Ms. Sonia Cooper, Senior Patent Attorney, Microsoft. Welcome, ma'am. Over to you, sir. Dr. Debasis Datta, I call upon you.
We will first start the session, and we'll have 15 minutes for each of the panelists to share their views on the challenges and opportunities in building sustainable global IPR for promotion and innovation in the ICT sector. And first of our panelists to speak would be Dr. Raymond Lutz. I will just read out a profile of Dr. Lutz. Dr. Raymond Lutz is currently the Vice President and Director General of Legal and International Affairs at EPO. Dr. Lutz has a long distinguished career in the field of intellectual property rights. Before joining EPO in 2011, he was President of the Federal Patent Court, Munich. From 2000 to 2005, Mr. Lutz was Deputy Director General for Commerce, Economy, and Intellectual Property Law in Federal Ministry of Justice in Berlin. So from his profile, you could read he has all the acumens of the IPR total ecosystems. And I will request Dr. Lutz. Share that views with us.
Yeah, thank you very much, Mr. Dutta, for this friendly introduction. So you can see perhaps that from this CV that I'm not a technician, I'm not an engineer, I'm a lawyer, and therefore I will more focus on legal issues or organizational issues than on technical issues. And I will mainly give you a view what patent offices can do in this world of challenges and opportunities and the IPR ecosystem. It was mentioned in these speeches this morning by Mr. Nathan that perhaps patents are not the ideal protection system for ITR
Should I put up the
innovation.
presentation?
Sorry, there is some technical. I just mentioned that it was said this morning by Mr. Nathan that perhaps the patent system is not the ideal protection for inventions in IT. This is a question we have also for a long time discussed in Europe, and the outcome is or was, well, not for all inventions in these fields a patent is the right protection, but for many. Over about 10 years we have then, well, tried to find out the ideal level of protection we provide for IT innovations within the EPO and with our examiners, with our experts in this field. And what our approach is nowadays, that, well, there must be a technical effect in addition to the software to provide then technical protection by patents, and it should be not only a plain software, not only the program which is protectable, but also innovations where there is a technical effect perhaps not deserves all patent protection, but nevertheless you should think whether it is necessary and whether it is helpful to have these protection. I could provide you a slide which shows the filings, the patent filings, well, between 2004 and 2013. And you can see that there is a huge increase of patent filings, mainly coming from China. The yellow part is the increase of patent filings from China. In 2004, China had about, well, 150,000 patent filings. Today, they file every year close to 1 million patents. And also in the other offices, in the USPTO, the gray one, or the Japanese and Korean one, the filings are at least stable, mostly increasing. And a huge part of these filings are filings where IT inventions are the basis. And this shows you also, or confronts you with the facts that there are filings, there are patent filings, and in your reflections whether you go the patent protection way, you should also look at these facts that others are protecting their innovations, their inventions by patents, and they are successful, they are economically successful, and therefore innovators also in India should reflect whether this is not a good way also to go this way. Yeah, this increase of filings the patent offices are confronted with is a real challenge for the offices, because, well, they are not staffed in a way to deal with, in China, for example, 1 million patent applications, or at the EPO with 250,000 every year. But nevertheless, the users expect a speedy procedure, they expect a uniform procedure, and mainly also the same outcome at all the different offices. What we can do is that we harmonize more and more our patent procedures in the world, not only in Europe. In Europe, you know, we have already harmonized a lot of our procedures, mainly completely, but in the world, to profit, to use what other patent offices have done and to reuse this in our own procedures. Because there is also a fact that about 250 to 300,000 applications are more or less the same in these five huge big patent offices. And why not using what the others have done when we examine then these patents? A very, very important element is the economic impact of patents, and whether it is really advisable to seek for patent protection, or on a broader way on IP protection. There are not only patents, there are also utility models, there are also design protection, and last but not least also trademarks. To find out which impact IP protection has on growth, on the economy, we did a study together with the European institution, the European Trademark Office, in 2013. And the outcomes were also for us very, very much surprising. The outcome was that in Europe, more than 35 million jobs are created directly or indirectly by patent-intensive industry. And our GDP is very much influenced by these patent-intensive industry. About 14% of the European GDP depends or is directly or indirectly influenced by patent-intensive industry. And this is for us a convincing argument to deal very closely and very intensively with these tools. Patents are just tools to protect the inventions you make, and to make it better usable in the economy. Yeah. What can patent offices do to meet these challenges? So there are three main strategies we have chosen, we at the EPO had chosen, and I will just very shortly explain it to you. The first one and the most important one for us is that we focus on a reliable quality and on business-oriented solutions with our patent strategies. We secondly have to improve our efficiency, to grant faster patents, not to make patents too expensive. And third, and this is what I already mentioned, we try to harmonize the global patent system in order to reuse, for example, patent work done in other offices in our own procedures. So, to reach this high quality in search and examination, it is important that you have, highly specialized patent examiners which get a training, which are up to date in respect of their knowledge on the technology. These examiners need state-of-the-art tools allowing efficient access to the databases available. And we provide our examiners, for example, databases with over 90 million patent documents coming from all over the world. And as it was already mentioned, we add since a few weeks now also Indian patent documents, which is very important that we get also Indian patent documents, that these inventions form also the state of the art. They contribute to the state of the art, and the patent examiners has to know also what happens in India in these technologies. What is also important is that you have a good access to this patent documentation. When you have 90,000 patent documents, it's very difficult to find out the right one for a specific invention. And therefore we have, together with the USPTO, improved our classification system. So we have now introduced in our office and in other offices, it is then also done, this new CPC, Collaborative Patent Classification System, with a very refined classification categories. About 260,000 little boxes for the different technologies are in this classification system, and this allows a relatively good access to the state of the art in the world, because, well, you know that patent examiners have not only to look at the state of the art which is produced by their own patent office or in their own regions, but they have to search in the worldwide patent documentation. This cooperative patent classification is already used by the Chinese patent office, by the Korean patent office, by the Russian patent office, by Brazil, Mexico, and so on. Especially important is here that the Chinese patent office is using these, SIPO is using this classification because they produce every year about 1 million new patent documents. If they are not classified correctly, it is very, very difficult to have access. There is also the language barrier. When you have, well, no clue what is in these documents, then you cannot search these documents, and you grant perhaps patents where there is a prior art in a Chinese document, and in a litigation then you lose your patent, and perhaps not only your patent but also some money. And therefore we are very happy that SIPO has accepted this classification system as their own system, and they are now for already a year classifying, and they do it very well. They do it very, very well. Another important information system for our examiners, but also for the broad public, is the so-called global dossier. This global dossier was introduced by the so-called IP5 patent offices. These are the big patent offices like USPTO, Japan Patent Office, European Patent Office, Korean Patent Office, and Japan I've already said. Which one is missing? China, yeah, China. In respect of applications, the biggest patent office today. So what you can find in this global dossier, under this global dossier heading, is all family applications. So I mentioned already that there are about 300,000 same applications in the different systems, and with this global dossier you can check the procedures, the state of the procedure in all the different offices by through one access. We have it on our website. Everybody can free of charge access to this, and you can see what the state of play is in the different offices in respect of a certain application. And this is very, very helpful for the industry because they can check whether they are on the right way in their argumentation in the different jurisdictions. So the next, try to meet the challenge is improving the efficiency of our European Patent Office. Well, we are a relatively young office. We just celebrated our 40th birthday a year ago. But nevertheless, we have also need to reform our procedures, procedures in respect of HR, in respect of how we deal with each other, and therefore our president has started a reform process 5 years ago, and we are more or less midterm in respect of these reforms. I do not want to go into details here. It is more an internal EPO process, but it has a very strong external effect, because the goal is that when our internal procedures and our internal approaches are, well, more efficient, then our output will also be higher, and this is then of advantage for the users. And in fact, we will improve our output, our productivity this year. So this is the statistics until now. We will increase our production by 14 to 15%. Thanks to this reform process and to the engagement and commitment of our examiners and of all our staff, for sure. But sometimes this commitment needs also support from the management. Third part of this approach is harmonizing the global patent system. Well, there are different areas where harmonizing is necessary. There is the European system, which can be further harmonized. There is the worldwide patent system, which can be further harmonized. I will start with the European system. Well, 40 years ago, when the European Patent Office was created, we implemented a system where the European patent grant procedure was completely harmonized, and the European Patent Office was tasked to do this patent examination for all the member states. Today we have 38 member states, so we have one patent grant process in Europe for 38 member states, which is a huge success and a huge harmonization effect in Europe. But this harmonization ended after grant. So the validation and of patents was then possible in the different participating member states, 38 as I said, but these were then procedures before these national offices. So if you would like to have patent protection in 5 or 10 or 20 of these European offices, then you had to go to each of these offices to validate your patent. And here I can announce that there is a further step in harmonization, and this is the already mentioned unitary patent. With this unitary patent, which was accepted by 26 European member states until now, this unitary patent provides then a harmonized procedure also for the post-grant phase. So after the granting, you as a user can then validate your patent, your granted patent from the EPO in up to 26 member states by one go, with one procedure, and these procedures will then be done by the European Patent Office. No longer with the national patent offices, but directly with the European Patent Office. And we are then also responsible for the administration of these patents, these validated patents, in terms of, well, collecting the annual fees, a very nice task, and in, well, changing the register when there are changes of ownership and so on and so on. And there will be then a central register where we inform then all the users on the state of these different European unitary patents. And in addition to this unitary patent, there will be a unified patent court created. This is an extremely important harmonization step. So we will have not only then a European Patent Office, but also a European Patent Court. And this court will then be responsible and will be the jurisdiction for these future unitary patents, which will be, well, available in perhaps beginning 2017. But this court will also be will have the jurisdiction over the already granted European patents. So there are about 1.5 million European patents validated in Europe, in the different European member states participating in this system. And this court will also be responsible for these patents. For a transitional period, it is nevertheless possible to opt out of this jurisdiction. So if somebody thinks, well, I'm happy with a national procedure in Europe, national courts in Europe, then they can send a letter to this court and indicate that they would like to opt out with a certain patent from this new legal system, this unified patent court system. This will be possible, and I could imagine that there are some patent holders doing this. But over time, after the end of this transitional period, which is for the first time 7 years, all other patents will be then under the jurisdiction of this new court. And I mentioned already that this is a huge harmonization effect, because then this court defines what is patentable and what is not patentable, more or less. And this is then a binding decision for all participating member states, and this gives us really a much better situation as we have today. So this I have already mentioned. Just to mention another, well, step to not to harmonize only, but also to enlarge a bit the extent of and of the effect of a European patent. We have in the last month signed so-called validation agreements with states which are not and cannot be member states of the European Patent Organization, because they are not in Europe or they are not willing to join the EPO, but they are willing to accept patents granted by the EPO as patents in their country. So, for example, in March we have signed and implemented such an agreement with Morocco. So a European patent can now directly be validated in Morocco without an additional examination procedure in Morocco, and the same patent as granted by the European Patent Office will then be